Uh, Good morning all, back for some more. As I mentioned in my previous video, I'm just going to run through what I believe are the issues with my deed. There may be some useful information here for you also. Once again, I'm not making any claims, I have no remedy for you. First of all, as I pointed out in my previous video, this deed, the deed being used by Kensington, and the deed which is registered at the land registry, and the deed which they entered into the court, is a direct copy of the original expired deed, but with some Tipex and an alteration. Now, before I continue with all of that, I'd just like to point out that the FCA in this document, public document, they ruled that in the Money Partners Conditions Booklet 2014, they contained some terms which were likely to be unfair under terms of Consumer Contract Regulations 1999. Kensington were basically told they had to change these terms within the booklet. They didn't. They instead produced a notice of undertaking saying that the terms in the conditions booklet would be not used. They would rely on the terms which they were ordered to change to. Now, unfortunately, what appears to have been overlooked by the FCA and by Kensington, in fact, some of those terms which were deemed as being likely to be unfair are actually on the face of the deed. Now, does this mean that the deed also contains terms which are likely to be unfair? Anyway, that bit done. Also on the deed, I wish to point out, when I actually signed the only deed which I have signed, which was back in February 2005, on the deed, I'm actually signing to acknowledge receipt of the advance. Now, I could not have acknowledged receipt of the advance back then. This was way back in the beginning when the terms and conditions were being negotiated. Just another point to put out to you. Have a look at that. Anyway, we have our two deeds, as I mentioned in my previous video. I'm just going to run through what I believe are the issues with the deed. So, we have, first of all, the clear alteration. So, this deed is a direct copy of this deed, both certified as being true and exact copies of the original, bar for some pretty crude Tipexing and a new date added. Now, with regards to alteration, this is what I believe in the law. We have the rule in Pigot's case, 1614, is 400 years old. Don't be put off by that. The old ones are the best. It means they've stood the test of time. They haven't been repealed or rebutted or whatever else you want to call it. The rule in Pigot's case, when a lawful deed is raised, whereby it becomes void, the obligor may plead non est factum, it's not my deed, and give the matter in evidence, because at the time of the plea pleaded, it is not his deed. Secondly, it was resolved that A, when any deed is altered in any point material by the plaintiff himself or by any stranger without the privity of the obligee, be it by interlineation, addition, raising, or by drawing of a pen through a line or through the midst of any material word, then the deed thereby becomes void. Addition, I'd like to point out in there. Now, that is written in Old English, it's quite old. How I believe the law now stands is, because there has been some changes made to it, any material alteration made to a deed without the consent of all parties renders the deed void. Now, with alteration, how are we allowed to alter? We have Pigot's rule. The Council of Mortgage Lenders Handbook, for example, in section 5.18.1, clearly The mortgage deed must not be amended. Chitty on Contracts, 31st edition, alteration or cancellation of a written instrument, paragraph 25-020, material alteration. If a promisee, without the consent of the promisor, deliberately makes a material alteration in a speciality or other instrument containing words of contract, this will discharge the promisor from all liability thereon, even though the original words of the instrument are still legible, which they're not. The rationale for this rule is twofold. First, no man shall be permitted to take the chance at committing fraud without running any risk of losing by the event when it is detected. And second, that the effect of the alteration renders the deed or instrument no longer the deed or instrument of the party charged. So, that's just the alteration. We have a recycling issue. So, this had expired, then they copied it, added some Tipex and a new date, and then recycled this deed for use with another contract. Now, case law. In R, on application of Mercury Tax Group Limited and another versus HMRC 2008, Lord Justice Underhill states within that case law, have a look, it's a public document, I have been referred to no authority which deals with the situation in the present case. That is, the taking of a signature page from one document and recycling it for use with another. At the bottom, the requirement that a party sign an actual existing authoritative version of the contractual document gives some, albeit not total, protection against fraud or mistake. So, we have an issue with the recycling. As he mentioned, a signature and actually signing the document. I'll run on to signature. Now, sorry, I'm lost here. Lord Denning, the virtue of a signature lies in the fact that no two persons write exactly alike, and so it carries on the face of it a guarantee that the person who signs has given his personal attention to the document. Accordingly, in practice, it appears generally accepted that, irrespective of what may suffice in law, the signature on a deed should be written pen in hand. In practice, also, such a signature would be attested, witnessed. Now, I signed that. I never signed that. I've never paid that document any attention. I never signed that pen in hand. In fact, I never seen it until they admitted it in their witness statement. More on signature. The Land Registry, Practice Guide 8, Execution of Deeds, Section 2, Paragraph 2.1. Signature. To be validly executed as a deed, each individual must sign the document. Must sign the document. I never signed that document, I signed that one. That is in accordance with Section 1(4) of the Law of Property Miscellaneous Provisions Act 1989. The attestation witnessing by a witness. Each individual must sign in the presence of the witness who attests the signature, and that is Section 1(3) of the Law of Property Miscellaneous Provisions Act 1989. Because I never signed that, I signed that one, that couldn't have been witnessed. So we have the witnessing. Now I'm going to run on to why I believe it's a forgery, a false instrument altogether, alteration and recycling aside. So, the Forgery and Counterfeiting Act 1981, Section 1, the offence of forgery. A person is guilty of forgery if he makes a false instrument with the intention that he or another shall use it to induce somebody to accept it as genuine, and by reason of so accepting it, to do or not to do some act to his own or any other person's prejudice. just so we know what false means in the context of the Forgery and Counterfeiting Act 1981, Section 9 of that Act, meaning of false and making. Part 1. An instrument is false for the purposes of this Act if it purports to have been made in the form in which it is made by a person who did not in fact make it in that form. I didn't make it in that form, I made it in that form. Number 2, if it purports to have been made in the form in which it was made on the authority of a person who did not in fact authorise its making in that form. I didn't authorise that. If it purports to have been made in the terms in which it was made by a person who did not in fact make it in those terms, and authorises the next one. Now, this was made in the terms which are plain to see in my application form. Those weren't the terms which I agreed to. I knew nothing of that application form. So were these documents made in the terms in which I agreed or authorised? I don't think so. Anyway, Section 9, Part 2, important again, because even if people decide that it's not a forgery for those reasons, Part 2, a person is to be treated for the purposes of this Act of making a false instrument if he alters an instrument so as to make it false in any respect. Back to the alteration. So even if Section 9 Part 1 doesn't count, Section 9 Part 2 surely does. Now, there's a few bits in here now. Person makes a false instrument with the intention that he or another shall use it to induce somebody to accept it as genuine. For example, the land registry or even the county courts. So I'll run through some case law quick and then I'm done. I'll get out of your hair. You can have some peace and quiet for the day. Since the decision in Wellham versus the Director of Public Prosecutions 1961, and this is the standing case, I believe, in forgery, it is now clear that in forgery, an intent to defraud may exist without an intent to inflict economic prejudice or to make financial gain. As stated in the Law Commission Report number 55, Criminal Law Report on Forgery and Counterfeiting Currency, at paragraph 31, Lord Denning frames a wider proposition in these terms. Put shortly, intent to defraud means with intent to practice a fraud on someone or other. It need not be anyone in particular, someone in general will suffice. If anyone may be prejudiced in any way by the fraud, that is enough. Paragraph 32 of the report states, the essential feature of the mental element in forgery is an intention to induce another to accept the forged instrument as genuine and by reason of that to do or refrain from doing some act. So I believe this document was changed to this document as an alteration, or I believe it was forged totally, to induce the land registry and then later on the courts into believing that that was a genuine document where I have paid attention to it, pen in hand, as Lord Denning states. In the approved ruling, as corrected 24th of February 2014, so it's a recent one, in R versus Evans and others at Cardiff Crown Court, just down the road, the economic explanation is sufficient, but in that special line of cases where the person deceived is a public authority, like the land registry or the county courts, or a person holding a public office, deceit may secure an advantage for the deceiver without causing anything that can fairly be called either a pecuniary or economic injury to the person deceived. Lord Denning put it thus at pages 132 to 134. What is the common element in all of these cases? It is, I think, best expressed in the definition given by East in his Pleas of the Crown, Volume 2, page 822. He treats the subject, I think, better than any writer before or since. To forge, in brackets, a metaphorical expression borrowed from the occupation of the smith, means, properly speaking, no more than to make or form But in our law, it is always taken as in an evil sense, and therefore forgery at common law denotes a false making which includes every alteration of or addition to a true instrument. There's been an alteration and an addition. There's more, but I just thought I would point out why I believe that deed is about as invalid as you can get. Thank you very much again for all your support, all your help. I've met some truly tremendous people, some genuine people. Have a good day. Thank you very much. More to come.